Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Honorable Justice Nayanala Jayasuriya of Andhra Pradesh High Court, while dealing with the case of Mr. Nelaturi Sukumar versus State of AP, represented by the DGP, State SHO, Ongole One-Town Police Station, Madam K.V. Subhashini, held that a customer who visits a brothel cannot be made an accused. A customer who visits a brothel cannot be made an accused. He can be made an accused if he is earning on the prostitution, if he is making earnings in the prostitution. He can be made an accused if he is the owner of the concerned brothel. But since he is a visitor, he cannot be arraigned as accused in the particular case. So this is the decision. Of course, lot of decisions were there previously also, but still people, the police authorities, to maintain the so-called law and order, they will be lugging in or they will be arraigning these people as accused in the cases, because there should be some fear. So before dealing with the case, let us know the details of the case. Since I am from Ongole, I can get all the information. This relates to crime number 333 by 2021, registered under sections 4, 5, 6 and 7 of the IT Act, that is Prevention of Immoral Traffic Act 1956. Right. So, on receipt of reliable information, the Inspector of Police, Madam K.V. Subhashini, she along with her staff raided a brothel in Bhagyanagar second line or someplace, Ongole, and she found certain victims, that is people indulging in prostitution, that is women, and also 3 persons. In Telugu we call them as vitulu or customers. So she has treated that woman from Padalakur as a victim, and she arrested these 3 young boys who were there actually as so-called visitors or as customers under the above sections of law. She arrested them, brought them to the police station, and later, of course, they were released on bail. Subsequently, she filed a charge sheet. The charge sheet was taken on file as a CC number 2292 by 2021 on the file of Special Mobile Court, Ongole. Yesterday only, Avala Salome, very recently, yesterday only she joined as a magistrate. Of course, now the FIR and charge sheet have been quashed by Honorable Justice Nayanala Jayasuriya. She filed the charge sheet. Now, against to the filing of the charge sheet, this man, Nelaturi Sukumar, he filed a case. He filed a quashed petition under section 482 CRPC before the Honorable High Court of Andhra Pradesh. Yes. He alleged that, or he contended that sections 4, 5, 6 and 7, they are not maintainable against him, because he was the person who visited the brothel as a customer. So the visitor is actually no more res integra, no more legal to book him. Please remember, actually the court relied on so many judgments. One such judgment is Padala Venkata Sai Rama Reddy versus State of Andhra Pradesh last year, 2021. So please remember, this clearly stated that continuing the criminal provisions against the person who was present in the brothel as a customer. Please remember, at the time of raid by the police, definitely he cannot be fastened the liability as an accused. So this is the important decision. No doubt, I don't encourage you people to go to the brothel and get caught by the police. But the legal provision, it clearly says that this customer cannot be booked as an accused. It is nothing but it would amount to, that is what is called the abuse of process of law. Alright, let us have a cursory glance toward the sections. Section 4 of the Immoral Traffic Prevention Act, it says, if any person lives on the earnings of a prostitute, earnings of the prostitution, yes, he is liable under section 4. Before that, if you learn section 3, it will be better. Section 3 says, suppose if the plaintiff is running a house as a brothel, he is liable. If he is living on the earnings of the prostitutes, yes, he is liable. Now section 5. this is actually dealing with the brokers, agents. Suppose if anybody tries to procure women for the purpose of prostitution, yes, it is an offence under section 5 of the IT Act. Then what about 6? 6 is detaining woman or preventing woman to go away from the brothel. So actually when she rejects to carry on the prostitution, if she wants to go out, if you detain, then he is liable under section 6. Then section 7 deals with the prostitution nearby a public place, I believe. So section 7, if the brothel means, please remember, brothel means not a prostitute. Brothel is a place, brothel is a house where the prostitution is being carried on. That too, the prostitution by women who do the so-called act for promiscuous sexual intercourse. So I need not explain, because as an elder I don't feel embarrassing to tell all these words. You please refer to the dictionary, this word I told you. Who do the so-called act for a promiscuous sexual intercourse. Suppose if it is for pleasure, it is not at all brothel. Please remember. Now the apartment culture has made it very easy for the people to go and enjoy the so-called activities, right? So section 7 deals with the prostitution in the vicinity of the public places. So this man, Nelaturi Sukumar or Sukumar, he has not involved himself in any of these things as stated by the police. In the charge sheet also it was not written. Simply they have clubbed all these things, made a mess and filed the charge sheet. So the High Court, it's not easy. They have gone through the documents and immediately they could find out that there is something. Therefore, they have clearly given a quashed proceedings. Of course, the other 3 persons, Mr. Komargi Ashok and Pamuri Veerababu or somebody, I don't want to tell their addresses. If they go to the court, same thing will happen to them. Why I have disclosed their names is because it has come in the court. It has come in the press also, or not press, in the judgments also. So you can read the case as Nelaturi Sukumar versus State of AP and CI KV Subhashni in criminal MP number 5630 by 2022 on 27th July 22, decided by Honorable Justice N. Jayasuriya. So please go through the judgment and enrich your legal knowledge. Thank you very much.